first case of the morning is State v. Robinson. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
Your Honor, I'd like to reserve 3 minutes for rebuttal.
Thank you. I'll note that. We'll be keeping time up here. I will try to let you know when you get to about a minute left in your time, and I'll counsel do the same for you when you're at time. After that, I won't give you any warning during rebuttal. The argument is being recorded. Please keep your voice up and remain behind the podium when you're presenting. Please introduce yourself when you come to the podium. Do not use the name of any child, minor, or victim in this case. If you would, please use initials or designation, child, minor, or victim. With that, the parties have read your brief and ready to proceed whenever you are.
May it please the court, counsel for the state. Good morning, Your Honors. Jacob Wilk and Attorney Marie Nicola on behalf of Marlon Robinson, the appellant in this matter. Your Honors, the issue we have before the court today is whether the trial court erred in denying the appellant's motion to suppress. And inside of that statement or assignment of error, we have 2 separate issues we'd like to bring to the court's attention for decisions in this matter. The first is whether the parole officer involved in the search of Mr. Robinson was lawfully permitted to exercise a protective sweep of the residence where they located Mr. Robinson. And then the second issue is whether the plain view doctrine is applicable in this matter and whether it was properly relied upon to obtain a search warrant for this residence. I know the court's read the briefs, but I would just like to provide a brief factual background to maybe set the stage here. Marlon Robinson was on parole. He was being supervised by Parole Officer Liggett. Back in February of 2023, he was deemed a parole violator at large. And essentially, that meant that there was a standing parole warrant for his arrest. At the suppression hearing in this matter, Officer Liggett testified that he had been surveilling and investigating Mr. Robinson for some period of time, up to 6 months. On or about February 9th, 2023, they're running surveillance and officers believe that they see Mr. Robinson driving a vehicle and heading to an address in Akron at Edemeyer Court. So, based on the surveilling officers and Officer Liggett, they essentially establish a perimeter around this address. They watch as a female, later identified as Carla Camacho, leaves the residence, and then they go and knock on the door where they believe Mr. Robinson is present. As they enter and approach the residence, they sort of form a stack, a tactical configuration for their safety. Knock on the door, announce their presence, and Mr. Robinson exits the residence. At that time, he is frisked, he is searched, no contraband is found, and he is taken into custody without incident.
Counsel, did he actually exit, or was he in the threshold of the door?
Your Honor, my understanding is that he opened the door, they observed him in the hallway, he stepped out, and was arrested outside of the premises. And I believe that's an important fact for us to consider because once he is taken into custody, it is our position that parole's job is complete. They have successfully executed their parole arrest warrant. Further, because they don't find any contraband on his person, there's no additional indicia of criminal behavior afoot at this point in time.
Counsel, but what if they knew there could be children inside?
Well, that's an interesting question, Your Honor. I guess what I would suggest is, what if there was information that there were children in the house that could provide some additional support, perhaps, for a protective sweep? But I think what's important factually about this case is that the officers wait and see Ms. Camacho, the resident of this apartment, leave. They watch her get in her car and leave at sometime at 8 o'clock in the morning, give or take. Then they watch as Mr. Robinson comes back to the residence in a car with no one else in it. So while I appreciate that in the transcript there was some suggestion that they didn't know if anyone else was present, there was no indication that there were other people in the house at that point in time. So what I want to focus on is that this
suggested, was there any testimony from the officers that they had reason to believe there were children in the home?
I would suggest no. That what was stated at the suppression hearing was that Officer Liggett asked Mr. Robinson if other people were present, and he claimed on the stand that he was not given a clear answer one way or the other. But I think what sort of carries the day with respect to this issue is the very fact that they rely on a protective suite to go in and justify their presence in this house.
What their testimony was, when they're at the hearing, what was their testimony as to why they went in the house?
The testimony for why Officer Liga went to the house was because he wanted to ensure officer safety and therefore do a protective sweep of the residence and the rooms inside. Obviously, they did that, and they found no one. But that did lead them to discover contraband, which ultimately led to a search warrant. But back to the actual entrance into the property, this is what I think is so interesting about Mr. Robinson's case, Your Honors. He's on parole, and obviously, if you're on parole, you are subject to very extreme limitations on your Fourth Amendment rights to be free of searches and seizures. And it's codified, and it's brought up by the trial court, it's brought up by the state of Ohio. I'm sure they're going to argue it when I sit down. They did not rely on that status to enter the house. At no point during the hearing does Officer Liggett say, I went into the house because he lived there, and I was allowed to do it. That suggests that they knew he didn't live there. I think factually we can all agree that parole knew he didn't live there because they got a copy of the lease. He was not on the lease. Carla Camacho, his girlfriend, was on the lease. And she testified at the hearing and also established that he did not live there, did not reside.
But did she not testify that he watched her children?
Yes, she certainly agreed that he would come over to the house, come to the residence, stay there. But for the perspective of living there under the statute regarding parolees and their ability to contest searches, I don't think that fits here. And I think that Officer Liggett's actions support that. Had he truthfully thought that Mr. Robinson lived at this address, he would have been free to go in there and search it, and we probably don't have an oral argument in front of Your Honor today. But he didn't live there, and therefore they have to get in the house somehow. Their argument is it should be a protective suite.
If he didn't live there, does he have standing to object to the search?
Thank you, Your Honor. Yes, I would suggest that he does have standing. While residing somewhere, of course, gives someone standing, so does being an overnight temporary guest with some reasonable expectation of privacy. I appreciate that the trial court wrote a little bit about standing in their argument, but that wasn't something that was brought up really at the hearing by either the state or the defense. I would submit to the court that standing is not an issue here. There is ample room to suggest that someone can be a temporary overnight visitor with an expectation of privacy that does not fall under the ambit of the Ohio Revised Code and the statute regarding parolees and their property over residence. So again, I'm not contesting that the parole officers could have searched Mr. Robinson freely. They were, of course, entitled to do so, but they didn't find any contraband on him. So if this protective sweep is not otherwise justified, their entrance into the home itself is a warrantless search, and the fruits, therefore, must be excluded. That's important because we know that Ms. Camacho appears back on scene. She sees on her internal security cameras that officers are in her house. So she comes home. She comes back from her class that she was supposed to go to that day. And she says, you don't have permission to be in my house. And essentially, parole tells them, thanks, but we're going to go get a search warrant. We're not going to let you in the house. We're going to stay in the house. An interesting point to bring up is that Officer Liggett testified that once she arrived and said, I don't want you in my house, they all left and stood outside. But the testimony at the suppression hearing was supported by some videos that were presented by defense counsel. And those videos, as reflected in the transcript, showed that officers remained in the property inside the entire time they were on scene. So, one of the things that we brought up in our brief, Your Honors, is this concept of a stalking horse theory, of using a parole search to justify additional law enforcement investigation. And I think it's applicable here because, as we've discussed in the facts here, they watched Mr. Robinson get out of the vehicle before he ever entered the residence. And if their only goal was to bring him back into compliance with parole, they don't need to wait for him to go inside. They can just get him right there as he gets out of his vehicle. I think factually that really supports the idea that they were really there to find a way to search that property. So, Your Honor,
They testify as to why they didn't pick him up on a warrant before they entered the house, or as he was driving down the road. Was there any testimony to why they waited?
there's no testimony to that. I think what's perhaps indicative of why they didn't do that is because when they had the follow-up suppression hearing where they brought in the detective from the Akron Police Department who authored the search warrant, he told the court essentially that, hey, look, I was waiting to get word whether they were going to arrest Mr. Robinson so that I could get search warrant. It feels as though they were waiting for this opportunity to present itself with respect to the parole investigation and whatever subsequent investigation APD was conducting. We suggest that parole just simply did not have any justification to go in that house and search to see if other people were present because, again, he was arrested outside of the residence and there was nothing to suggest anyone else was present at that point in time. So that's our position with respect to the first prong of our argument about why the trial court erred in denying the motion to suppress. The second issue that we want to address with the court today is the concept of plain view and whether that's applicable to how law enforcement eventually got a warrant for the premises at Admire Court. Once the officers are in the house searching for folks in other rooms, they locate a firearm sitting on top of a bed in one of the back bedrooms. And once they find that firearm, Officer Liggett testifies that at that point we stop and we go and call for a warrant because now we want to be able to search the entirety of this residence. And so the warrant itself is predicated upon finding this firearm, according to the state, in plain view. The plain view doctrine has 3 prongs that need to be addressed before it can be found to be applicable. The first of those is, are the officers lawfully present in the place where they find the item? Second, was it inadvertently seen or discovered? And then third, was the item immediately apparent as contraband? And so I'll just briefly break down each of those. First, lawfully present. As we just finished discussing, our position is the officers were not lawfully present in this residence.
1 minute, counsel, just so you.
1 minute. So I would suggest that they were not lawfully present. However, if the court thought that they were lawfully present, plain view still is not going to save the day here, and I'll get to it right now. The inadvertent discovery, there's no issue here. Clearly it was inadvertent discovery. The firearm was found on the bed. They were not looking specifically in drawers. But was it immediately apparent as contraband? And I believe the answer to that is no. The reason I would suggest that it is not immediately apparent as contraband is that firearms are inherently not illegal. Moreover, even though Mr. Robinson is not allowed to own a firearm, he's not the one who lives at this address. That's his girlfriend, Carla Camacho, who was lawfully allowed to own and possess a firearm. The very fact that we have a person who lawfully is allowed to possess that firearm present and living in that house would be enough to suggest it's not immediately apparent that the gun is contraband. I want to contrast that. If the gun was found in Mr. Robinson's car, immediately apparent. That is immediately apparent contraband. He can't have a gun. If it was found on his person, immediately apparent. But found in a house someone else owns and lives at, who's allowed to own a gun, it is not immediately apparent. Because it was not immediately apparent, plain view cannot support a finding of probable cause for a search warrant. And as a result, Your Honors, the trial court erred in denying the motion to suppress. Thank you.
Thank you, counsel.
Please support counsel. Evan DiMartino on behalf of the state of Ohio, the appellee in this matter. We are asking that this court affirm the trial court's denial of Mr. Robinson's motion to suppress. With regard to the standard of review for a denial of motion to suppress, that presents this court with a mixed question of law and fact. If the trial court's decision with regard to the finding of facts is supported by competent, credible evidence, and this court must accept that, and then apply a de novo review of the law to those facts as found by the trial court. In this case, the trial court found in the journal entry on pages 3 to 4 that Mr. Robinson was a parole violator at large, which means essentially he was a fugitive. There was a warrant out for his arrest, that Mr. Liggett, the parole officer, was investigating and trying to determine Mr. Robinson's whereabouts, which were unknown because he was a fugitive, for approximately 6 months. Due to surveillance on that day and then also prior to, they had determined that he was at least staying at his house in Admire, which would make it a residence. Clearly, if he had stayed in contact with parole and provided a residence, we would have had for sure
Counsel, would it have to be his residence, or if Mr. Robinson had Casey's permission to be in the residence and Officer Liggett had reasonable grounds to believe that he had violated the laws or the terms of his parole, what would that mean? Could they do a warrantless search?
I believe they could still do the warrantless search under 2967 131C and under case law that provides that they could do a search of him his vehicle, where he's staying. As a parolee, he was also told prior to being placed on parole, and the trial court entered that as a finding of fact, that Parole Officer Liggett testified that all parolees are advised that they are subject to warrantless searches of their homes, where they're residing, their vehicles, their person, etc., because they're on parole. So that is all in the findings of fact, which are supported by the testimony of Officer Liggett. So while the defense would like this court to believe that there was some other reason for going into the home, none of that is in the record. What is in the record are competent, credible testimony presented by the adult parole authority through Officer Liggett, who was supervising Mr. Robinson and was assigned to investigating his whereabouts for approximately 6 months. His testimony was that they saw him going into that home. They followed him in a vehicle. He left for McDonald's. He came back. That they knocked on the door. When he answered the door, they asked him to come out, and he complied. They asked him because they knew there was a possibility that there were children in the home. That was the officer's testimony on page 11 of the transcript. And Mr. Robinson did not say yes or no when asked whether there were children in the home. And based on that indecisive answer, the officer...
They mean who decided to answer? Did the parole officer enter, or did the Akron police officers, the revenue department, did they enter the building?
Multiple officers entered the home, and they did that. The testimony by Officer Liggett was they went into the home to do a parole protective sweep, and that I believe is on page 11 also, which was to search for bodies, basically looking to see if anyone was in the homes. There was no testimony to support the theory that the defense is trying to articulate. There's nothing that was said to support a finding of fact that they went into the home for any other reason than to secure the residence, to make sure there were no other people in the home. So while there's some argument to say they were doing surveillance and they knew that the girlfriend had left and they knew that he had left for some time, neither one of them, there's any testimony that they had a child with them. So there is competent, credible evidence in the record that the question was asked because there was a belief that there could be children in the home. It was not answered definitively, and that is the reason why the protective sweep was done. And that would be permissible under State versus Leeming, which is a 9th District case, as well as the Ohio Revised Code, ORC 2967-131C, because Mr. Liggett was on parole and was clearly in violation of the terms and conditions of parole by virtue of the fact that he was a violator at large and had a warrant for his arrest.
So as I understand then, does the record from the officer's testimony show that they went in, A, because there may be children, and B, because they wanted to do a protective sweep pursuant to their statutory authority to do so?
Protective sweep for bodies, not for evidence, correct? To secure the residence, that's the testimony. And based on that, those findings of fact, if you take those findings of fact as true and you apply the law with regard to protective, to plain view, then you would find that the officers were in fact in a place where they were lawfully allowed to be. There's no dispute that the discovery of the firearms on the mattress in the bedroom was inadvertent. And then that would certainly be incriminating evidence with regard to Mr. Robinson, because as they stipulated on parole, he would not be allowed to have a firearm. So it is in and of itself incriminating. While the girlfriend may or may not have been permitted to have a firearm, I don't know what her conditions are, that is irrelevant as to whether or not it was incriminating with regard to this parole violator at large who was not permitted to have that firearm. And from there, the officers did what they were supposed to do, which is then get a search warrant for the residence based on the incriminating evidence which they found in the home, which would be the firearm that Mr. Liggett was not permitted to have. If there are no other questions, I will rest on.
Does that depend at all, again, going back to whether it's his residence?
I do not believe so. The testimony was also, it's kind of like they want to have it both ways, right, with regard to the girlfriend's testimony. She testified that he helped with the bills, that he helped watch the children. If you take that part of her testimony and find that that was credible, that would support the theory that he's at least staying there. He doesn't have an established residence that we know of. It took 6 months to find where he's been staying. What we have found, and the officer testified, but he testified that it looked like Mr. Liggett was occupying there. So whether it was his permanent residence or his temporary residence, he certainly was staying there. It's the only place that the parole officer was able to find that he'd been staying over the course of that 6 months. he felt confident in going where he would find Mr. Robinson and then be able to take him into custody. There was never any testimony that the only thing they wanted to do was arrest him and get him into accordance with his parole applications. The testimony was, if someone's just missing and they're on parole, maybe what we do is get them back on parole. But if there's also other charges or other things that come up, certainly that person might not just be placed back on parole. And there was testimony that he was wanted on other charges, but there was no testimony that the reason for this search of the residence or anything else was a way to get around the investigation and try to expedite a review or an interview or anything else with regard to any charges. So based on that, the state would ask that this court affirm the trial court's decision denying Mr. Marlon Robinson's motion to suppress.
We wouldn't expect the officers to testify if we did the search in a way to really get around warrant requirements. I mean, obviously not going to testify to that.
They could
when you make a point of it, of course they're not going to say, well, we're trying to get away around the warrant requirement, that's what we think we're going to do.
But they could testify that we were looking for evidence as well into another investigation when they're under oath to tell the truth as to the basis for their search.
I think one of the appellant points is that they were looking for the person for 6 months. They could have pulled him over on the road. They could have pulled him over before he got in the house. From your perspective, is there any evidence on the record of why they waited so long?
No, and the officer was not asked that on cross either. So there is no evidence either way, other than they were conducting surveillance, they watched this long, and then they knocked on the door.
And I take it, your testimony is he did not have a residence located with the parole department, or at least the one he had was.
No, he
was not.
Right, he was at large, which the officer explained meant he was a fugitive, and that he also had a warrant for his arrest based on that.
Thank you.
Thank you, Your Honor. Just briefly on rebuttal, I guess I just want to sort of address what we're discussing here with why parole decided to go into the residence. The testimony was very clearly that it was a protective suite. Had they believed he was actually residing there, they would not need to use that argument to go into the house. He would have just said on direct or cross, I had statutory authority to enter because he lived there. The fact that he didn't rely on that tells us what we need to know about this particular issue. I would suggest that there was other evidence presented at the hearing, specifically with Detective Patrick at the follow-up hearing that happened at a later date, where they were actively investigating Mr. Robinson for another case. That case never came to fruition. No charges were ever filed. But Detective Patrick testified that he was actively investigating Mr. Robinson. And so that's why this idea of a stalking horse, this theory, I think, has real application in this case. I would submit that they needed to say it was a protective suite because otherwise they couldn't get into that house. And again, ample opportunities to arrest him prior to going in. In fact, they waited for him to go in, set up a perimeter, and then went and knocked on the door and asked him to come out. In addition, with respect to whether someone else was in the residence or not, I don't know, I'm going to quibble with this point, but if you think there are children in there, kids, you're not going into the residence to make sure that officers are safe. That would be under the guise of maybe a welfare check, or we need to make sure that there's not an infant crawling around that's not going to have a parent here when we arrest Marlon. So, I think the parole officer is trying to have it both ways. I'm going to get into the house because I want to search the rooms and make sure no one's going to harm me or my fellow officers. Okay. But the basis for getting in can't be, I thought there were a couple of small children that were crawling around and needed help. Again, Your Honors, based on what we've outlined in the briefs, and unless there are any other questions, we would rest on that, and we would ask that you reverse the trial court's finding and remand this case back to the lower court for further proceedings.
One last question. Is it your position that did the parolee have the express or implied permission of the owner of the residence to be there?
That question, I don't think was directly asked of the owner of the residence.
Would it matter if there was a express or implied permission given?
Well, I think it would matter with respect to the standing issue if we were bringing up standing. But I don't think that it necessarily changes the analysis under the revised code 2967 with respect to a parolee and his residence and what can be searched. Again, if this was an address that was on file, there's no question they're allowed to search it. And I go back to the fact that did Officer Liggett think that he had a residence that he was living at there? If he did, he doesn't need to tell anyone about protective suite. We don't need to rely on that at all. I'm just going in because he lives there, and because he's on parole, I can search anything he lives in. That's not what happened. I think that is telling. If there's no further questions, we will rest on the ground. Thank you.
Thank you. The court will take the matter under advisement and will issue a decision in due course. The clerk of court will mail a copy of that decision to you upon its release and will also be available on the High Supreme Court's website. With that, I'd like to thank both parties for the presentations and on behalf of the court.